You know the concept of the butterfly effect, right?
Sure, chaos theory. A butterfly flaps its wings in Brazil.
And you get a tornado in Texas. Exactly. So no, take that idea and just drop it into a courtroom.
Okay.
You're in a bar, it's crowded, you bump someone, just a little stumble. But what you don't know is they have this incredibly rare condition, a literal eggshell skull.
Right.
That tiny bump is fatal. Now, the question isn't physics, it's murder. Are you a killer? Or just impossibly unlucky?
It sounds like a riddle, but yeah, that's a real nightmare scenario the legal system has to untangle all the time.
And it works the other way, too. You know, a doctor misses a diagnosis, they're negligent, you suffer, but it turns out you were really, really sick to begin with.
So did the doctor actually cause the harm, or was it the disease all along?
Exactly. And that's the gap, right? That messy, sometimes contradictory space between I did a thing and I am legally responsible for the result.
And that is exactly what we're going to try and unpack in this deep dive.
We're looking at the legal concept of causation. And I have to say, our stack of sources today, we've got these dense academic papers on criminal law, focusing on a famous case called Blau, and then these practitioner guides on clinical negligence. The two sides seem completely schizophrenic.
You can feel that way. You've got criminal law over here, which is, very focused on moral blame.
Right.
And then you have medical negligence, which is just obsessed with statistics and probabilities.
So our mission today is to figure out where that line gets drawn, because, as we'll see, you can be the direct cause of someone's death in one court and walk away not liable in another.
It forces the law to decide which domino actually matters. Is it the first one you pushed, or the third one that was already wobbling?
So let's start with the baseline. All the sources keep coming back to this one thing, the but-for test.
Yep, that's the gold standard. It's the gatekeeper. And the court asks a really simple-sounding question. But for the defendant's action, would the harm have occurred?
So if I hadn't done my thing, would the bad result still have happened?
Exactly. If the answer is no, the harm wouldn't have happened without you, then you're on the hook. But if the answer is yes, it was going to happen anyway.
You're clear.
You're clear. On causation, at least.
And the classic example of this, it's just a total tragedy of errors, is a case called Burnett v. Chelsea and Kensington Hospital.
Ah, the arsenic case.
Okay.
Every law student knows this one.
It's so vivid. So it's New Year's Day, three-night watchmen, been drinking tea, and they show up at the A&E just violently ill.
And the doctor on duty? Well, he's negligent. That's the simple way to put it. He's tired. He won't even see them. He tells a nurse to send them home.
Which is a huge breach of duty. You just can't do that. So the men leave, and one of them goes home, gets into bed, and dies a few hours later.
It turns out the tea was spiked with a massive dose of arsenic.
Just horrific. And his widow sues the hospital. I mean, they failed him.
No question they failed him. But the court has to apply the but-for test.
And this is the twist. The evidence showed that by the time he walked into that hospital, there was so much arsenic in his system. He was basically already dead.
Yeah. Even with immediate perfect treatment, the antidote wouldn't have worked in time.
So apply the test. But for the doctor sending him home, would he have died?
Yes.
He would have died anyway.
Therefore, no causation. The negligence didn't cause the death. The arsenic did.
That feels so cold. It's basically saying you messed up, but you got lucky because your patient was doomed.
It is cold. But in civil law, it all works on the balance of probabilities. You have to prove it's more than 50% likely that the defendant caused the outcome. In Barnett, the chance of saving him was 0.
Okay, so that's the baseline. If it's inevitable, you can't be blamed. That makes sense. But now, let's pivot to criminal law. Because reading about this thin skull rule, it feels like they throw all that logic right out the window.
Criminal law is a different beast. The stakes are different. We're talking about punishment, not just compensation.
So what is the thin skull rule?
The saying is, you must take your victim as you find them. So if you punch someone, and it turns out they have literally an unusually thin skull, and they die from a punch that wouldn't normally be fatal.
You can't say, well, I didn't know he was so fragile.
Nope. The law says you chose to commit an act of violence. You own all the consequences, no matter how unusual.
Okay, physically, I get that. But the sources all focus on this landmark case, R.V. Blau, where the thin skull wasn't a bone, it was a belief.
Right. Blau is fascinating.
Yeah.
So 1975, a man stabs a young woman. It's a serious wound, penetrates her lung, but it is treatable. She's rushed to the hospital.
And the doctors say they need to do a blood transfusion.
Yes. They say, if we give you blood, you will almost certainly live. If we don't, you will die.
And she says no.
She refuses.
Yeah.
She was a Jehovah's Witness. And she believed accepting a blood transfusion was against God's law. She died the next day.
So if I'm the defense lawyer, my argument is obvious. I'm saying I didn't kill her. The wound wasn't fatal. She chose to die.
And that is exactly what they argued. They said her decision was unreasonable and it broke the chain of causation, that she caused her own death.
But the court said no.
Absolutely not. They ruled that the person who uses violence on another must take his victim as he finds him. And they made it clear that's not just the physical body, it's the whole person. That includes their religious beliefs.
So her refusal wasn't a new intervening act.
No. The stab wound was still the operating cause. The court basically said it's not the attacker's place to judge whether his victim's religious beliefs are reasonable.
And this is where the academic sources get really interesting with this debate between Klimchuk and Williams.
Right. Klimchuk defends the ruling with what he calls the equality principle.
The idea that the law can't judge the value of a religion.
Exactly. He says if the court rules she should have taken the blood, it's treating her as less of a citizen because of her beliefs. To respect her, you have to respect her choices as part of who she is.
But then Glanville Williams comes in from the other side and says, this is just crazy.
Williams argues there's a huge difference between a weak heart and a belief. You can't choose your heart condition. You can choose what to believe and how to act on it.
He thinks her choice should break the chain.
Yes. He says if perfectly good treatment is offered and refused, that's a free choice. The defendant shouldn't be on the hook for that.
One of the papers brings up some wild hypotheticals to test this, because Blau is about religion, which society generally respects. But what if the reason for refusal is stranger?
Or more offensive.
Right. What if someone refuses a transplant because they think organ donation is cannibalistic? Or, and this is the really tough one, what if a racist victim refuses blood because the donor was a different race?
And that really pushes the rule to its limit. If you follow Blau strictly, you have to take that racist victim as you find them. The stabber is still a murderer.
That just feels wrong.
It does. And the sources suggest a court today might try to find a way around that, maybe by drawing a line between religious conviction and unacceptable beliefs, but the law is very, very murky there.
It's also interesting to contrast Blau with another case, R.V. Roberts, the Daphnis test.
Ah, yes. The woman who jumps from a moving car.
Right. The driver is making sexual advances, trying to take her coat off, so she jumps out and gets injured. He says, hey, she jumped, that's on her.
And in that case, the court asked, was her reaction reasonably foreseeable? Or was it, in their words, daft? Totally bizarre and unexpected.
And they said, no, it wasn't daft. It was a predictable reaction to being attacked, so he was liable.
But notice the difference. In Blau, the court didn't care if her reaction was foreseeable. Most people would not refuse a life-saving transfusion.
That's the tension. In criminal law, if you create the danger, the courts really, really don't want to let you off the hook.
The moral blame of the initial attack just outweighs everything else.
Okay, so criminal law is you started it, you own the result. Now let's swing all the way back to medicine. Because the clinical negligence cases on loss of chance feel like a parallel universe where the defendant gets all the breaks.
We're back in the world of statistics. And this is where the but-for test can be incredibly harsh on patients.
The case that just made me want to throw the papers across the room was Hodson.
Hodson's the key case, yeah.
So a 13-year-old boy falls out of a tree, hurts his hip badly, he goes to the hospital.
And they mess up. They completely miss the fracture for 5 days. Because of that delay, the blood supply to the hip gets cut off, and he develops this permanent, lifelong disability, a vascular necrosis.
And the hospital admits they were negligent. They say, yep, our bad. But then the experts look at the fall itself.
And the fall was bad. The medical evidence showed that there was a 75% chance that the fall itself had already destroyed the blood vessels. He probably would have developed the condition anyway.
So that leaves a 25% chance that proper, timely treatment could have saved his hip.
Correct.
And the first judge, the trial judge, tried to be fair. He said, okay, you lost a 25% chance of a good outcome. We can't give you full damages, but we'll give you 25% of the total.
Which makes sense to us, right? You lost something of value. A lottery ticket with a 1 in 4 chance of winning is worth something.
But the House of Lords said no.
Overturned it completely. They went back to that strict but-for test. You have to prove it was more likely than not, over 50%, that the negligence caused the harm.
But the chance was only 25%.
Exactly, below 50. So, in the eyes of the law, the negligence caused nothing. He got 0.
That is just brutal. A 1 in 4 shot at a normal life is legally worthless.
And it gets even more stark in a case called Greg v. Scott. That one was about cancer.
The doctor misdiagnosed a lump, right? Said it was benign, but it was aggressive lymphoma.
And here are the numbers. If they had caught it early, the patient's chance of surviving 10 years was 42%. Because of the negligent delay, that chance dropped to 25%.
So the doctor's mistake nearly halved his odds of survival.
It did. But look at that starting number, 42%.
It's under 50.
Exactly. So the House Lord said, even with the best treatment, you were more likely to die than survive. So on the balance of probabilities, you were already doomed. The negligence didn't cause your death, it just made an unlikely survival even more unlikely. No liability.
The source calls this the lure of 51%, this crazy cliff edge. So if you start with a 51% chance of survival and a doctor drops you to 49%, you get everything. But if you start at 49% and they drop you to 0, nothing.
That is the harsh math of the but-for test. The law really struggles to put a value on a chance. It wants a yes or no answer. It doesn't do maybe.
But surely that gives doctors a free pass to be negligent with their sickest patients. If a patient has a 40% chance of survival, I could just go play golf instead of treating them. And if they die, I just say, well, they probably would have died anyway.
That is the exact criticism. It creates this legal black hole for patients who are already seriously ill.
So why do the courts stick with it?
I think it's a fear of opening the floodgates. They worry that every case would become a complex argument about tiny percentage points. They think it would just become unmanageable.
Okay, so but for is a high wall. But the sources do talk about workarounds for when things are too messy for simple math.
Right. Which brings us to material contribution. Sometimes you just can't untangle the causes. A key case here is Bailey v. Ministry of Defense.
The patient who aspirated vomit.
Yeah, unpleasant, but legally very important. So she had natural pancreatitis, but she also got negligent post-op care. Both of those things made her incredibly weak.
And because she was so weak, she couldn't clear her throat and ended up with brain damage.
So what caused the weakness? The natural disease or the hospital's negligence?
And you can't separate them. You can't say it was 60% this and 40% that.
Exactly. The but-for test just breaks. So the court used a different test. Material contribution, they asked. Did the negligence make a more than negligible contribution to the weakness?
Did it add to the pile?
Exactly. And the answer was yes. So the hospital is liable for the whole thing.
I love the analogy in the notes about guilty dust.
That's from an old industrial disease case. A worker gets a lung disease from silica dust. Some of the dust in the factory is unavoidable. That's innocent dust. But some of it comes from a machine that wasn't properly maintained. That's the guilty dust.
And once it's in your lungs, you can't tell which particle did the damage.
Right. So the employer argued, you can't prove it was my guilty dust.
And the court said?
Nice try. They said the guilty dust materially contributed to the overall risk. It added to the cloud of dust in the air. Therefore, you're liable.
It definitely feels like the courts are trying to be pragmatic there to stop defendants from hiding behind scientific complexity.
100%. Which leads us to the final piece of the puzzle. Sometimes you don't even have the science. You just have common sense.
Which is surprisingly powerful, like in the Shembri case.
Yeah, the GP case. A woman goes to her doctor. She's breathless. He fails to refer her to a hospital. She dies of a pulmonary embolism.
And the defense tried to argue, well, you can't prove that hospital treatment would have saved her, not for sure.
They tried to hide behind the uncertainty, but the court just took a pragmatic view. They said, look, you were negligent. And the thing that happened is exactly the kind of thing your negligence is supposed to prevent. We can just infer causation.
It's like a common sense presumption. If I drive my car into you, I can't argue, well, maybe your car would have dented on its own.
Right. We can infer that I caused the dent.
So let's try and pull this all together. In criminal law, with the thin skull rule, if I attack you, I'm on the hook for everything. Your rare medical condition, your religious beliefs, all of it.
You broke the rules by being violent, so you bear all the risk.
But then in medical law, with loss of chance, a doctor can be negligent but get off completely if you were already sick enough to fail that 50% probability drug.
Right. There, it's all about proving the damage was actually caused by the doctor, not that it was inevitable.
It feels like a massive contradiction. Criminal law cares about the result. Medical law cares about the starting point.
I think it reflects their different goals. Criminal law is about punishing moral blame. Tort law is about financial compensation.
But it leaves us with this awful result where a 25% chance at a normal life or a 42% chance of surviving cancer is legally worth nothing.
And here's the final thought to leave you with from the readings. We talk about these rules as if the law is discovering some scientific truth about what caused what. But maybe the law is just deciding who should bear the risk of uncertainty.
What do you mean?
In the Blau case, the law puts the risk of the victim's unusual beliefs onto the attacker. In the cancer cases, the law puts the risk of scientific uncertainty onto the patient.
That is. Yeah, that's unsettling. It's not about truth, it's about policy.
Exactly. And it raises a huge question. If we hold a stabber responsible for a victim refusing blood, why don't we hold a doctor responsible for slashing a patient's survival odds from 42% down to 25%? Is the loss of hope not an injury in itself?
That is a big question. And one I think you'll be chewing on for a while. Next time you hear about a court case, just look for the before.